Welcome, everyone, and good afternoon. We are thrilled to be presenting this very timely panel, Pandemic Trials, Defending Criminal Clients During COVID-19. This webinar is sponsored by the ABA Section on Civil Rights and Social Justice and the ABA Standing Committee on Legal Aid and Indigent Defense. This is one in a series of many rapid response webinars that CRSJ are producing, and we are actively planning additional programming on a variety of issues. So please regularly check the websites for updates on these programs. During today's program, we encourage you to ask questions of our panelists. Please put those questions in the Q&A portion, not the chat function. If you do not see these controls, maybe check that your screen is not idle and is on full screen. I will try and incorporate as many questions as I can into our panel today. We're going to be sharing a recording of this program to everyone who's registered, so you can share it within your networks if you enjoy it. And with that, I want to turn to our panelists and introduce them. With us today is Alicia Bannon, Managing Director of the Democracy Program at the Brennan Center for Justice at NYU Law School. Zach, I failed to ask you how to pronounce your last name, and I'm going to butcher it.
It's Hlavaty. The H is silent.
That's what I would have guessed, but okay. So Zach Hlavaty, Public Defender, Metropolitan Public Defender in Portland, Oregon. Kelly Villanueva from the Metro Division of the Office of Public Defender in New Mexico. And Loren Williams, Deputy Public Defender in Alameda County Public Defender's Office in California. And I am Malia Brink, Counsel for Indigent Defense at the ABA Standing Committee on Legal Aid and Indigent Defense. So I want to just jump us right in to the subject. We are going to start with Alicia and ask her to give us a little bit of an overview. At the Brennan Center, you've really been following what's happening with the courts and analyzing concerns. So before we talk to all of our public defenders about the specifics of what's going on in their jurisdiction, can you just take us through the variety of ways in which the courts have endeavored to adjust to the pandemic and what some of the kind of biggest trends you've been seeing are?
Absolutely, and thank you so much for having me and for organizing this great panel. I'm really excited for the conversation. Look, I mean, after with the arrival of COVID-19, courts have been building the airplane as they have been flying it. In the initial aftermath, when COVID-19 sort of first landed in March, you saw kind of broad closures of courts across the country with limited exceptions for emergencies. But since then, you've seen a number of different reopening strategies in the court systems, including in the criminal courts. We've seen a dramatic expansion of the use of remote proceedings for many kinds of criminal proceedings, also a limited return to in-person jury trials, as well as a number of different hybrids. So on the remote front, a lot of jurisdictions already authorize the use of remote proceedings for limited numbers of criminal proceedings, things like arraignments, first appearances. And so one thing we've seen was just a dramatic expansion of things that were already on the books. Many states also expanded what you could do remotely, including pleas, sentencings, bench trials, some of which might have been on the books in some states, but there was a dramatic expansion and use of that as well. A few states, Alaska and New Jersey, have convened remote grand juries. Texas had an online misdemeanor jury trial over the summer, kind of an experiment, but that's been very limited. We haven't seen, that's been very rare to see a remote jury trial. Typically, jury trials have been in person or at least in a hybrid. But overall, like I said, I think one of the big trends has just been that dramatic expansion in the use of remote proceedings and a series of challenges, which I can talk more about. But everything from challenges to the attorney-client relationship, just tech issues in general, issues around credibility determinations or other sorts of evidentiary matters. So I'll be happy to talk more about what we've been seeing nationally, and I'm sure there's a lot of stories from the defenders on this panel. With respect to in-person proceedings, like I said, there a number of states have returned to having in-person jury trials. To a limited extent, it has sort of waxed and waned as COVID rates have waxed and waned in a number of states. States have varied in the kinds of measures that they've undertaken to preserve safety, things like plexiglass boxes, spreading out juries, see-through masks, things like that. Often we've seen limited public access. So even if all the other court participants are in the courtroom, many states have closed courtrooms to the public and are either live casting trials or having separate rooms allocated for the public. I'd say, and then we're also seeing hybrids. So like I said, we've seen the use of remote access for the public in trials that are otherwise in person. We've also seen extensive use of remote video for witnesses, including in circumstances where ordinarily you would have seen them in person. And just in terms of other implications for those proceedings that have been proceeding in person, I think there's been a real different approaches and inconsistent approaches in terms of safety provisions. So I think that's one trend or one thing that we've been seeing as obviously something of great import in how states have been responding. There's been a number of instances where trials have also had to have been halted because of individuals coming up with a positive COVID test. So that's been another way that many of these proceedings have been disrupted. And even in those jurisdictions that have in fits and starts been returning to using in-person jury trials, the backlogs in many places are really staggering. So just to give one example, in New York City between March and November 2020, state and federal courts conducted a combined 9 criminal trials. During the same time period in 2019, they had 800 criminal trials. And, among other things, that's left in limbo hundreds of people in pretrial detention.
Thank you, Alicia. I want to turn to Loren and ask you to tell us a little bit about trials in California and in Alameda County in particular. And I just ask if you could tell us a little bit about what trials are happening and how they're happening in your jurisdiction.
Sure. So in Alameda County, which is Oakland, Berkeley, an expansive county in the San Francisco Bay Area, we have returned to jury trials, I would say sometime last summer after there being a halt. And since that time, there have not been a lot, but it's been fairly consistent. We have been doing in-person jury trials. The jury trials, they tend to move a little slower, primarily because of the jury selection process. Most recently, we've had several trials go out just at the end of 2020 and the beginning of 2021 here. I did a trial where they called in a panel. You get a very limited amount of people who are coming in. The process is very sort of elongated because you're only able to question a few people at a time. So we have had jury trials going out, but it has been slower. I don't know if you want me to talk about the details of it, or you just wanted to get a sense of what we're doing in Alameda County right now.
Yeah, just sort of in general, but what are the cases that are going to trial? And
right now, the way it's working is the trials that are going out are either no time waiver trials where the defendant has not waived any time, meaning they have demanded to have their jury trial within 60 calendar days of the arraignment on the information in the case. Those cases are sort of statutorily required to go out once the Supreme Court lifted the total ban on the proceedings. So those are the cases that are primarily going out. At this point, we also have cases going out that are time waivers that are very old, where the prosecution is sort of lobbying for those to take a courtroom to get them resolved. And that can be for any number of reasons, maybe witness issues or just a case that they want to get off their docket. Those also seem to be going out. And then the third category are homicides, and those, whether they're time waiver or no time waiver. If they are in a position where the DA really wants them to go out, then we're having judges sending those out. It's put actually the defense bar in a very difficult position because we don't know until we get to a readiness date whether or not the case is going to go, because it used to be if it was time waived, like there is no limit, then it was going to get continued. And recently we've had several attorneys, private and public defenders, surprised to arrive at a pretrial hearing date and told that their trial is actually going to go forward, or to put them in that position where they have to get ready very quickly. So that's mostly what the trials are that are going out right now.
Great, thank you. Zach, how does that compare to Oregon?
That's pretty similar in Oregon. So in Oregon, we have a 60-day speedy trial statute for any criminal case, misdemeanors, felonies. And so what's been happening is, anyone that's not waiving time and comes up to the 60 days, we also, however, have a good cause statute that a judge can sort of extend it over any defense objection, 60 days again, and then 60 days one more time. So really cases could go out to 180. And all the cases that are going now are major felonies. So child sex abuse, robberies, kidnaps, serious assaults, because our jail is just typically releasing more of the minor felony and misdemeanor cases. And therefore there's sort of a less strict speedy trial right that the clients can exercise. And so it's similar to what Loren was saying, is that we'll have 30, 40 cases set for trial in a particular week. And our court right now has capacity for about 3 trials because they use multiple courtrooms for each trial, one for the public, one for the trial to actually take place, and one for jurors to deliberate in. So we only have the capacity to do 2 or 3 trials in a week. And so everyone shows up to the trial readiness sort of date, and then the judge has to do some mathematics as to who's at 60, who's at 120, who's at 180. And if they're at 180, do we risk letting this person out or sending that one to trial? So it's all been major felonies for the most part. There was an attempt to do, in Oregon, it's only 6 folks on misdemeanor jurors. And so they tried to do some out of custody misdemeanor cases. And that proved difficult because of juror availability and again, taking up a courtroom that potentially could be for, another major felony case that has, time waiver issues.
Kelly, how does that compare to New Mexico?
In New Mexico, I believe in district court, they only did a couple of jury trials before jury trials got suspended by our Supreme Court. We did do some jury trials prior to that in Metro Court, which is only misdemeanors. Right now, felony and misdemeanor jury trials are set to resume on February 1st. We right now are doing kind of video bench trials, which is what the Supreme Court has allowed to still continue. And there's several issues with that as far as like confrontation and things like that that we've encountered. But we're just kind of figuring it out as we go along.
What's the volume? So like Zach said, they really have the capacity in his court to do 3 a week. What's the volume of video bench trials happening?
Well, sometimes there's 3 or 4 going on at once because we're kind of scrambling for rooms. We're using our conference room, our training room, 2 other conference rooms, and sometimes they're all filled with attorneys, and the attorney and the client and co-counsel are all in the room together. So we try and get kind of a big room. So there's as much, room as possible to not get sick.
So I want to spend a little bit of time talking about the in-person trial. So I'm for a minute going to talk a little bit with Loren and Zach. Both of you in your introductions mentioned juries and the problem of getting juries. And I want to kind of dig a little deeper on that. What is the selection process like? Have you seen kind of a change in composition? Are you just having trouble getting juries?
I can speak to that, I guess, first. So in Alameda County, it's been twofold. So one, anecdotally, a trial I did at the beginning of the year, you have summons sent out to 150 to 200 people on one round, and I believe we got 26 people that showed up for the jury in the jury room on the day that it was they were set to come. And then they sent out another set of 150 to 200, and I believe they got like 20 people that showed up. Now, this was also at the time when California had just put basically the entire state on a shelter-in-place, stay-at-home order, so it's not surprising. And in Alameda County, I believe that potential jurors who are summoned are able to call and just get an immediate deferral without even, stating a cause of any kind. So that would explain why so few people are coming. And then of those people that showed up for the trial that I did, maybe 6 to 10 of them had immediate hardships, meaning they came just to say they didn't want to be there because of COVID. And so those people are immediately released. So in a trial that I had on a serious felony, we turned out to have about 31 jurors to pick from during jury selection. So it's very problematic, and it raises the issue of whether you're getting a sufficient cross sample of the community in your trials, especially in a case with mine, which involved an African American defendant, and there was no African American jurors in the entire pool of people that showed up. So I think that does raise a lot of issues with this current COVID state that we're living in. And then as to the quality of the jurors, I will say that of the jurors that came, I noted that there was a disproportionate amount of what I describe as naturalized citizens who actually were there, people who weren't born in the United States. I just thought it was very striking that it seemed to be that cross-section of the community that was most committed to showing up for their jury service. So I think that's something to take into consideration. Overall, I would say aside from that group, there was a particularly educated and liberal bent, I thought, or at least a criminal justice interest in most of the people that I talked to. They wanted to be there. They wanted to talk about the issues. So I thought that was very interesting. We've had some very good outcomes with our juries, with trials. We just had a complete acquittal on a homicide earlier this week from an attorney in our office based on a self-defense. The jurors just acquitted him, walked him out the door. So we've had some good luck, but I don't know, Zach, what's going on in Portland?
So we've seen, in terms of the outcomes, mixed results. I think one of the first trials, and again, it sounded like the facts weren't great on a robbery, but the jurors were out 15 minutes and quickly came back guilty on everything. So we've seen mixed results in terms of the composition. The way that we're doing jury selection is in panels, taking up. So all of our trials start on Tuesday. They'll do, a morning trial, or depending on pretrial motions, an afternoon panel, a morning panel on Wednesday, an afternoon panel on Wednesday afternoon. And for each of those panels, they're sending out 50 summons, and we've had, some days where we've only gotten, 25 folks to show up for that panel. And so we've had issues with the numbers of folks that have shown up, and we're trying to get sort of a copy of they're also sending out sort of a deferral form that basically is, a blanket statement. I'm concerned about COVID and not showing up. And so we're trying to get our hands on a copy of that to potentially challenge the cross section of the jurors, because I've also had mixed panels of sort of COVID science deniers, like this isn't a big deal, I'm not showing up with a mask, I don't want to wear a mask type panels. We've had panels where it's all, mostly been sort of middle-aged, like a lot of young. I had a jury panel where it was, almost strictly sort of 35 to 55. We had no elderly folks and no young folks on any of the panels, and that was, interesting there. So it's been a long process because everything in Oregon, you can only have 25 folks in a room. So depending on if there are interpreters and bailiffs and such in the room, we can only do panels of 15 to 18 people. And then they're liberally letting, cause challenges go if anyone, does show up and then mentions they have a COVID concern or a COVID concern for a family member. And so it's taken longer and we've needed tons of people that we just don't have sort of available for these panels.
So are you just objecting, like putting it on the record and sort it out later?
Yeah, I mean, we've had, where the first panel of 15 show up and all of a sudden 4 people, the judge will in their precautionary instructions ask, is anyone concerned? And some folks will speak up and others won't. And then we get into voir dire and then someone will say, oh, well, by the way, I have a 90-year-old grandmother at home. And if this trial is going to take 2 weeks, I don't really want to be coming and sitting in this room, 9 hours a day with 25 people and going home to this person. So then they get kicked for cause. And then we're having to grab from sort of that pool because they're doing them in panels. And we've run out of people and needed to get, third and fourth panels of people to come in. So it's been sort of a mix. It feels like it's getting better as time has gone on. It feels like people are sort of going stir crazy and more willing to show up just to get out of the house to show up for jury duty. But at the beginning, it was very slim and, sort of COVID science deniers that were making up a lot of our panels. Malia, I think.
I also want to talk about the procedures once they're in the room. So you're dealing with these jurors, you're trying to conduct voir dire. You can't do it all at once. But in addition, are they masked when you're questioning them?
Yeah, so at the beginning of COVID, so I think the first trial we had here was the end of April. And so, masking was sort of a touchy topic or, was less widely concerned. And so we had, I think about half of the panel would wear masks and the other half weren't. Now, like our presiding judge has put an order, everyone has to be masked at all times. And they're spread throughout the courtroom. So you've got folks, 25 yards away from you and just sort of scattered out. And so it takes a lot more and you're just having to take more time to get to each juror because you can't read their facial expressions if someone's answering a question one way or people, look like they've just got a blank stare on their eyes. And so you're really having to take time to go to everyone and just reiterate asking if everyone can hear, if they understand the questions being asked. It just takes so much longer.
And in Oakland, the way they've done it is they have the courthouse that we have 2 different courthouses, but the courthouse that I'm more familiar with is sort of the large, very ornate courthouse, very high ceilings, very large rooms. In that courtroom, they've been doing 15 potential jurors at a time, sort of 3 in the jury box, sort of in a V formation. So they're fairly far apart. And then in the audience, which is maybe 10, 11 rows, they'll have them maybe every 4th seat, maybe every 3rd or 4th seat. And that's how they've been bringing them in. Now, one thing to note is that they supposedly in the jury selection room down on a different floor, supposedly the jurors that aren't in the room are listening to what's happening in the courtroom so that you don't have to repeat all your questions, so that they have a sense of what's going to be asked. But inevitably, when the jurors come up, you ask them, did you hear what we've been talking about? And all of them are like, we couldn't hear anything. And you just kind of have to start over every time. And that's really with the way that they are doing it, as they're doing it with 15 people and a 12-person jury. They wait until the 4th person is kicked so that you only have 11 jurors, and then they'll refill with 4. So every time 4 people go off, 4 more come, and then you have to go over the whole thing they haven't heard, and you have to sort of repeat everything at a time. So it's very time consuming. and tiring, because you're also having to sort of do a voir dire in the round, because you've got some people in the jury seat and some people out in the audience, and you've got to sort of be turning and making sure your back's not to people. It's very.
Uh-oh, you cut out. I think your thing muted you. Your earphone. Yeah.
I stopped. I was done.
Okay, good. Well, before we actually get to trial procedures, my question is: you're talking about most of the trials are motivated by the fact that you have in custody clients who are running out of speedy trial time and refusing to waive it. That brings up a whole other set of issues about how you actually interact with those clients to prep for these trials. How is that working? Are you actually allowed to visit? Are you having to do it sort of exclusively through online procedures?
We're allowed to visit the Santa Rita jail, which is our county jail. You can do non-contact visits. Some people are doing them, most people are not, mostly because Santa Rita has had a very poor run with preventing outbreaks in the jail. There's currently, I think there are 80, maybe in the 70s of inmates who have COVID who've tested positive right now. My guess is that the deputies are bringing it in. I mean, they would say it's the inmates, but I would say it's probably the deputies that are bringing it in. So there are not too many people doing that, but we do have access to, after several months, I would say maybe September, October, we were finally given clearance to do video interviews remotely. So it used to be you'd have to go into our office, which is also kind of frowned upon right now, into a little room where people would talk to their clients. But we now have software where we can actually do this from home, like where I am now, and we have access to link up to that same video system. So that's been really helpful to be able to prep with clients, to show them videos over the screen and to talk to them. More difficult, and I'm interested in what Portland is doing, is trying to communicate with your clients during the trial, because there is social distancing at the actual counsel table as well.
Yeah, but before we get to trial procedures, because I have a lot of questions about that, but Zach, why don't you tell us a little bit about what it's like to prep with clients and what access you have?
Yeah, so out here, they are only doing professional visits, so we are able to meet with our clients. None of the visits are contact visits unless you absolutely need to. You have to get our office, has us get approval from our office, and then the jail has to approve the contact visit, what the purpose is for. And so there are some extra hoops to go through. We do have attorneys that are at high risk, and their cases have been reassigned to other folks that are at a less risk, I suppose, if the client is, not willing to waive and wants their trial. So the prep has been pretty much the same. We've had the same access. We are just now getting phone access to our clients for us to be able to call. So our clients can call into the office, but if we're not there up until this week, we haven't been able to call into our clients. And so it's really been, there was a point, I think, over the summer where, half of our attorneys were either at risk or had family members at risk or childcare issues. And so, our office was down to only a few attorneys that were sort of able to take cases to trial. But in terms of the pre-trial prep, we've still been able to go into the jail and meet with clients adequately.
And just a quick question, are they actually testing you and or your clients and or your jurors before you start trial?
No, there was talk of doing temperature checks, and that is sort of half-ass being done. It depends on who's working the security desk, if they do it or don't do it, but they don't do any sort of COVID tests and not regularly doing even temperature checks for jurors, attorneys, clients, deputies, anything like that.
Is that the same for you, Loren?
Similar. They just put in the temperature check machines at the beginning of the year. I don't think anyone's really monitoring whether anyone's using that, particularly in the employee interests of the courthouse. As far as testing goes, we actually had this issue come up because there was an outbreak, another sort of wave of outbreak at the beginning of the year when several cases were being pushed out to trial. And there was actually a request by our office to test our clients before they're coming in that was denied by the jail, saying that they hadn't demonstrated any symptoms, they didn't feel they'd been exposed. So that was very problematic. I believe they have since changed that policy to now we can have our clients, especially ones who are going to be coming to court, request to be tested. Supposedly, they're saying that any inmate that requests a COVID test will be given a COVID test. I'm a little skeptical, but that is currently the what's being told to us about our clients. So I will tell you, in that case with the homicide that recently, the acquittal this week, last week there was an article posted by a reporter who was listening, who indicated that there was a juror who at a break did say that she had been exposed to a COVID positive person. My understanding from reading that article is that juror was excused in an alternate place, but that the jurors were not told that had happened. The remaining jurors were not told, which I thought was very interesting and did not seem quite right. I don't know. I haven't had an opportunity to ask my colleague how that went down or what happened, but that seemed very problematic.
Yeah. All right. I want to turn to the courtroom itself and ask about masking and social distancing procedures, and whether they're consistent and whether they're impacting your ability to communicate with your client, with witnesses, and with the jury. So Zach, tell us a little bit about how your courtrooms are being organized. You said they're using 3 courtrooms.
Right. So the way our courtrooms are set up, the judge is up there. They've got sort of a like hockey penalty box plexiglass thing around them. Their staff is on one side, the witness on the other side. No plexiglass around them. Juror box, we've got, on the side with about 3 jurors in there. Counsel tables in the normal spot, and then the remaining 9 to 11 jurors are behind counsel table. And then in terms of clients, they're sitting next to us. It was very inconsistent in terms of the ways judges would have, whether jurors need to mask, witnesses need to mask, attorneys need to mask. Now it's everyone has to wear a mask. However, the witnesses are asked to take their mask down while they're testifying. Our clients are asked to take their mask down if they need to be identified. The judges originally wanted to keep myself and my client 6 feet apart to show the jurors that, we were taking this seriously and whatnot. And I sort of said, on a child sex case, I'm not going to not sit next to my client when everyone already alienates them as it is, and I need to be able to talk to them. And so that's been difficult, especially, speaking through masks and having the courtroom set up so that jurors, even though they're behind you, are still far enough away behind you that they can't overhear confidential communications. But then the issue is a lot of the counsel tables, in some cases, we've been able to rotate them so that we can sort of look back behind us to see how jurors are reacting to testimony. But in many cases, we've got sort of no idea what anyone is accepting back there. And in one trial with a colleague at the end of the trial, there was a juror that said, look, I barely could hear hardly any of the testimony, even though continuously we're asking, please raise your hand, please let us know if you're having trouble hearing. So that's sort of the way it's been spread out. It's been especially difficult with interpreter trials because the interpreter is still having to sit 6 feet away. So it's been almost impossible to have confidential communications during trial with an interpreter. The judges have been as understanding as possible if we do need breaks to be able to talk to clients, but it is difficult, and it's difficult to read the jurors, I think, is the biggest thing, and make sure that they're able to see. Like I said, we've got folks that are 50, 60 feet away from the witness and probably can't see facial expressions, definitely are having hard times hearing.
Loren, is that sort of the same?
I would say Yeah, that is the same. I mean, the setup in our courts right now are everyone is required to be masked at all times. What was happening was that the witnesses would take the stand. They're sitting in a plexiglass, sort of, again, that sort of hockey penalty box situation that is somewhat insufficient in that it's maybe only 7 inches to the sides of them. So, there's a lot of air and that can go around the other way, around the plexiglass. But what I believe is happening generally is that the witnesses are being asked if they are, I believe that there are significant witnesses, complaining witnesses, percipient witnesses, people that really require that, or officers testifying, that they are having them remove their mask to testify. I noticed anecdotally again that the juror sitting closest to the witness box did not seem perfectly comfortable with that, and seemed a little distracted. And I made that note, and with that in mind, I think every other witnesses who were just laying foundation, in the particular case that I'm referring to, there was a lot of foundation witnesses that weren't providing, significant evidence. Those folks all kept their masks on while they spoke, and I think that was fine. I don't know if that's the case in every courtroom or how every judge is doing it, but I think it's probably some combination of, keep your mask on for some period of time, or some witnesses wear the mask while testifying and some don't. I think it's just probably at the discretion of the court.
All right, I want to turn to some of the online proceedings and bring Alicia and Kelly into this. Alicia, you started off by saying, and I think we were all sort of part of this at the very beginning of COVID, as courts started to turn to online. There was a lot of panic about what this would look like and how it would be put in place. Do you want to kind of tell us a little bit about what you have seen in terms of and looking into online procedures and some of the red flags that you've identified?
Sure. Well, I think one thing that's important to think about, and for policymakers to think about in particular, is that I think some of the benefits to remote proceedings in terms of convenience are very visible, and some of the costs can be less visible. So for example, we're still in the early phases of being able to assess anything about what if any impact remote proceedings have on, fairness, outcomes, like in any kind of rigorous empirical way. But, there is some older research that has been done of video proceedings preceding, pre-COVID, which is troubling and suggests that, that people appearing remotely, that there are potential impacts on, the ability to sufficiently assess credibility, that, video has a flattening effect. It can be harder to empathize, to, can sort of have a dehumanizing effect on people that obviously has huge implications in the context of even a hearing. And so, so I think one sort of set of concerns is, particularly when video proceedings are being used in any kind of, in the context of hearing witness testimony, there's a lot we don't know about what that might be doing to, with how that might be impacting outcomes and the fairness of the proceedings. Another aspect is, I think, the impact on the attorney-client relationship. Although I think it's interesting hearing some of the challenges even in person when people need to be maintaining social distance. But something that's come up a lot, and I've even seen just in observing some proceedings online, is just how hard it is. Even when the technology exists, and courts vary in exactly what kinds of platforms they've been using, but even when the technology exists to allow for, going into a breakout room to have a confidential consultation, it can be hard to do that. It can be hard to kind of halt a proceeding midway to confer with your client. We've gotten reports that people are reluctant sometimes to do that. And, and going back to what I was saying about the costs and the benefits being not always visible in the same way, I think it's been striking. There's been some surveys. There's an interesting survey that was done in Texas looking, interviewing or surveying judges, prosecutors, and defense attorneys in Texas about the experience that they've been having with remote trials. Texas has been one of the states really on the forefront of using remote video conferencing in the criminal context, and not just trials, but just sort of more generally in the criminal context. And there are really striking asymmetries of responses. So in areas like, how do you think it's affecting the attorney-client relationship? Defense attorneys, you have very high numbers saying we think it's having a very detrimental effect. Among judges, it's, very few identified that as a real concern. And on several dimensions in terms of how, defendants having their rights protected, feeling like, are they actually being disadvantaged in the proceedings? There's real asymmetry in those responses that suggests that policymakers, judges may not be fully attuned to some of the harms that might be manifesting. And like I said, we're sort of experiencing this in real time. So there's limited data yet to really point to be able to make that case fully.
Kelly, you're in a jurisdiction that's using these online proceedings, and having heard some of Alicia's red flags, do you think they're on point? What's your experience been with them?
I do think they're on point. Thankfully, we don't do jury trials remotely. We do just bench trials remotely. And what our DA has been doing, which is really frustrating, is they're dismissing charges out of cases so that it doesn't qualify for a jury. And so then we're stuck with this audio visual, like a remote trial via Zoom. And we have to justify, according to our rules from the Supreme Court, we have to justify something specific to our person, not just confrontation, not just those mere like constitutional things, but like something about our client, like either they need an interpreter or they're in custody. And in fact, the other day I checked to see if we had an in-person bench trial set because the client was in custody. And I checked to see if it was still on, and the secretary or the judge's assistant wrote back and said, "Oh no, that's going to be remote." And I said, "No, it's not, because we can't talk in real time to our client when they're in jail and we're here." So we're just not going to do that. So that's one of the challenges that we're facing. The other is now the time to talk about confrontation, or?
Well, I want to actually follow up on that, because that's a really important point. So in terms of these online proceedings, you've managed to at least limit it to bench trials where your client is out. And presumably you kind of said this is a little bit about client interaction. So how are you doing that? When you have a trial, where is your client?
Our client is like maybe 2 rows back, kind of to my right, so I can see them. And part of our rules that were put forth by the Supreme Court say that we are allowed to just basically take a time out and talk to our client, bench or jury. We can, so, if anybody starts pushing, we can just be assertive, because we are the bosses, because we do have the Supremes behind us, at least on that one little issue.
So you can just shut it down, go talk to your client, and then essentially restart.
Right. We could just say we need a moment or several moments, or we'll be back in 5. And we just have to, be assertive about that, because, our clients, and we just have to really hammer it into our client that if you have a question or you can't hear, because that's the other thing, is we can only have one computer sound going. Otherwise, there's this horrible echo. For some reason, we can't have like the big screen that the client is looking off of. We can't have that audio on. And if there's 2 attorneys in there, you can't have both attorneys' audio on. So my client is having to hear from my computer. So, we have to make sure, if to drill it into them, that if there's any questions that they let, just holler out,
Yeah.
Can I ask a question and then everybody go on mute?
Full disclosure, I've experienced that because I have gotten access to some of the Albuquerque Metro trials to watch them, and it really isn't. It's a terror, that one I have seen where you're getting that weird feedbacky echo. Are there other tech problems that you're having? Are there platforms that are working better than others?
Zoom works the best because there is a breakout room. Not that you need it for a trial type proceeding, but Zoom is the format that I like the best. There's other technical issues in that, the cops are trying to do these on their phone, and sometimes you can't hear them, or they can't see. They have trouble getting the right screen view if the prosecutor's sharing the document. They're having trouble being able to see that particular document to get refreshed or whatever, or, say that is what they say it is. So, that's a problem for them, which we like. Problems for us is just not being able to hear, because sometimes people's audio devices will kind of drop the second half of what they're saying. And, we went through a trial for like 4 hours, and the DAs kept doing that. And then the cops was doing that. And it was just really hard to continue to pay attention to a screen for that amount of time when you couldn't. I mean, you could kind of get better at lip reading, so that's good. But that's the kind of thing that we have trouble with. And then, well, I'll just leave it there. You're muted, Malia.
Yeah, I'm muted. I want you to talk about some of the places that you're finding particularly challenging. I think you mentioned identification issues.
Yes. So part of what we've been doing is, saying, can we have females join this this Zoom meet, and you send out the link, and can you please be wearing your mask and have your identification as my name, because that's how we put our client. If we're doing an ID issue, we have to notify the court within 48 hours ahead of time that ID is an issue in this case. And then even when we do that, the judges are just saying, defendant, could you please approach the camera? And so one person walks up to the camera, and the judge is like, well, is that the person? After they've told that person to come up. But the judges haven't. Some judges have allowed basically the video kind of lineup that we try and put forth. My judge was having none of it and seemed quite bugged that we had done it. And so she went to a YouTube link so that all the other people that had my name on their squares had to get off of the link so that the cop could see who just the defendant was. So, and appealing something like that. I mean, we could do that because I guess New Mexico has some of the best identification case law in the country. But the judges are just having none of it as far as to that issue. And some judges, even while they're denying it, are realizing that it's an issue and are feeling bad about it. So I think we're winning on other grounds because they're just like, this is kind of crap. So
that was the next question, which is, have you seen a difference in outcomes?
I mean, we don't usually win bench trials, but now we do. And I'm not sure if it's because of difficulties the state's having, or if it's because the judges don't want us throwing a snot slinging fit about in person. I couldn't tell you why we're having more success during COVID.
So I want to kind of open this back up to everyone and ask about the access issue, because I actually think it hits in person and online in somewhat the same way. And I want to start with friends and family, because the presence of friends and family in a courtroom often serves to humanize and contextualize one of our clients, even if they never speak. So, on person or online, are they able to be present in the setting of the trial? Zach, why don't you start?
Sure. So the first trial that we had, we brought up the whole, well, we have the right to have a public trial. And so they, decided to live stream the trial online so that anyone could watch it. The following trial was a child sex abuse trial, and they didn't want to, broadcast that online. And so then that's when they decided to set up a separate courtroom for anyone to come watch there. I think that, yeah, as you brought up, it's tough because the jury is not seeing the humanizing aspect of our client, that people are there every day sitting behind them to support them. And you also don't have the, sort of hostile witnesses sitting up there with people potentially against them, and that, can make witnesses sort of squirm on the stand. And there's less of that, happening because now they're just dealing with the jurors. So they have made sort of a concession to have it in a different courtroom. And there have been issues with that in terms of the technology or not having interpreters there for family members. We've had issues with, witnesses showing up to trial and court security not knowing, that this person is someone from the public or a juror or a witness. And when they ask court security, where is this trial happening? And they say, oh, you head to the viewing courtroom. And so we've had witnesses that are supposed to be sequestered and are instead watching other witnesses' testimony. So it's sort of been a nightmare there, and really unfortunate, I think, for both family members and our clients to not have the support of each other there.
Yeah. Loren, what's that like?
Yeah, in Alameda County, they have set up so for most of the court proceedings, we use a system called Blue Jeans, which is what we use instead of Zoom. I don't know why it's called Blue Jeans. But for trials, they have set up, in addition to Blue Jeans, which is audio and video, there's also something called a Rocket live stream, which is just audio, which is the access they're providing to the public. So there's no viewing courtroom. The courthouses aren't letting anyone into the courthouse that doesn't have, that can't point to their, having something on calendar or being a witness to something. So it's very limited. I've had, both in preliminary hearings and in trials, there have been family members that have wanted to know what was going on, and they're limited to the live stream audio, which often isn't very good. Sometimes the clerks forget to turn it on. There are all sorts of issues that go along with that.
Sorry, Alicia.
Oh, I was just going to say, I came across an interesting example in a district court in Idaho where a judge streamed, they had an audience sitting in another room, and then the judge streamed the video of the audience back into the courtroom to say that it was important for everybody to see all of the people that were watching, because, one of the values of the public trial is for people to be held accountable to the public. I thought that was just an interesting example of different ways courts are trying to wrestle with those issues.
Kelly, what is the access like for an online courtroom?
So I think they do send out the link, and it's just the regular link for court. So once court's over in the morning, that's when the trial starts. So it is a public link, and you can tell your client, if you want anybody to watch this, you can have them, go on to the court's webpage and find the link for this. But a lot of people can't figure it out or don't have a device that can work with Zoom, and they have a lot of difficulties. So, I mean, and that's one of the reasons why we have our client, in the same room as us, is because there are so many people that either can't figure it out or don't have the capability or the Wi-Fi to do this. But as for access, some judges will put it on a YouTube link and then people can just watch it, but otherwise it's just on Zoom. So it'd be like all of us would be on Zoom, and people could Zoom bomb it if they wanted to. But so far they haven't, unfortunately.
Yeah, I think we sometimes forget how many of our visual, like our cues about court are visual and kind of therefore and spatial. When you walk into a courtroom, you can figure out who the different players are by virtue of where they sit. And online court takes that away from you completely. And so, Kelly, what I hear and what you're saying is they might be able to get on there and listen, but the visual for the decider, and in your case, the judge, is not there because that person is not going to know whether those people are friends and family or, candidly like me, who's just on there observing and got the link from someone. Have you had the issue that Zach described where you've got witnesses who are popping in who really ought to be sequestered, but who turn out have been listening all along?
If that is happening, I think we would know about it. Like if one cop they're not supposed to be listening to one another testify, and we would be able to see if the other cop was on there because, we would have identified already, that's either the number they're calling in from or whatever. But I suppose that could happen. What's been harder for us is when we have a defense witness, we have to sequester them somewhere, and just the logistical elements of trying to figure out whose computer is that person going to testify from, and where are we going to hide them so that they're not listening to testimony, so the state can't try and suppress their testimony.
So even though you're doing online courts, you're not only bringing in your defendant to have communication with them, you're bringing in all your witnesses to your office.
The fewer things you can leave to chance, the better. I mean, and that's just been my experience is, if you want them there, you get them there.
It makes sense. It's funny to even call it an online trial. Half of it's in person, just not in a courthouse.
Right. I mean, they're just not providing the venue. We're still doing all of everything and trying to figure out how to do it. And they are just kicking it at home with their Starbucks.
And Malia, if I could just add on to that one, I agree with the last point. That's how it's working with our evidentiary hearings as well. But one thing I observed in a recent evidentiary hearing, our preliminary hearings, is that in a child sex case where you would normally, the minor testifies, normally we would exclude witnesses, including all potential witnesses, in this case, which would be parents or whoever the reporting party is. In this incident that I had, that was very difficult to do because I knew that the mother and father were downstairs probably listening in the DA's office. So it had to be a whole extra discussion and sort of, a declaration by the DA that they weren't going to be letting the parents listen to the stream downstairs. That's something just to keep in mind, because with audio, anyone can be listening who may not be a witness at that hearing, but is still a witness that should be excluded from the proceedings.
Yeah. So let me ask this, which is, you're going through all these procedures. They're very strange. Alicia pointed out, we actually have no data about their potential to impact outcome and so forth. Do you see things that you are likely to appeal? Do you have any hope for the appellate process in terms of these cases?
I'll start there. We've sort of been faced with we had some, motions that went out challenging the constitutionality of having a COVID trial based on confrontation and public trials and such. And so the courts, they pretty quickly found workarounds, but then they sort of give us / our clients the option, if you think this is unconstitutional, then I'm going to find good cause or whatever, or essentially force you into waiving more time. Or you can go forward with this trial and we're not telling you that you're waiving any sort of appellate issues, but if you brought it up and think this is not constitutional, but then decide to go to trial, it seems as if you're sort of de facto waiving those appellate issues. And so we have yet to see any any Court of Appeals opinions or anything happening from trials that have taken place, and it right now seems sort of grim in terms of being able to succeed at the appellate level on any issues.
Loren or Kelly, does one of you want to jump in? Kelly.
I don't, the one thing I would say as far as an appellate issue that seems that we may have won in at least the first district, California area, the Bay Area, is previously there had been no case law that defense could use to say that when our client waives a 60-day right, they then can they can set it at beyond 60 days, but to a date certain. There is no case law we could rely on. Very recently in an outlying county, we did just have an appellate case published come through that's saying that defendants can waive time to a date certain, and that does have to be complied with. So we consider that a victory. I don't know if it's been argued since it came out a couple of weeks ago, but we were pretty happy to see that.
Yeah, that's great. Kelly?
My experience has been more like Zach's, that, if you want this to be in person, then you can waive the 6-month rule and set it outside. And even some judges aren't allowing for that. So, I think, unfortunately, there is a pressure on a lot of, and who I deal with is misdemeanants. So there's a lot of pressure on people to get this over with, because this screws up their chance to get some jobs, their chance to, pass some background checks for, housing and stuff like that. And so a lot of people are just forget it. I want to take the plea because I need to get on with my life. And I think that unfortunately, and I'm sure that Zach and Loren's clients have an even more, vested interest in getting it done quickly, since a lot of them are in jail. So unfortunately, a lot of defendants are making decisions that go that way. We haven't had any success at anything in the appellate court, and I think the appellate court is going to be pretty backed up with things that are kind of more important than our cases for a long time. And so I think the interest in getting something resolved and not coming back 3 years later and having to do your first offenders program when you no longer drink, I think is kind of discouraging a lot of people from pursuing the appellate issues, because it is going to be so long.
Alicia, what are you seeing nationally on the appellate front?
Things are really just starting to kind of wind their way through, and I think with all of these backlogs kind of exacerbate that. My sense is that I think there is a sense right now you get to pick your constitutional rights. You don't get all of them at the same time, right? Like if you want a speedy trial, then you might need to give up your right to be present. There's that, and that because of it being kind of an emergent situation, courts are going to be very hesitant to be kind of messing with the systems that are being put in place. But I think it's still in the early phases of exactly how that's going to be playing out practically.
Thanks. I want to wrap us up, but I have 3 kind of last questions that relate to kind of a last question about what you're seeing in the courts, and then 2 questions related to the future. One of my questions is about pleas, right? There's a way in which everybody wants to avoid all of this pandemic trial issue. And I'm wondering if that's impacting the pleas you're seeing. Are they getting more favorable? Is there more pressure to plead, either because they're more favorable or because the prospect of going through this alternative process is so negative? And sort of what is the impact that you've seen on the plea process? Kelly, you want to start us off?
Sure. We have one client in particular that we share with the felony division, and he sat through all of COVID and sometime before COVID, waiting for his trial. And now he's facing, I think, 4 felony cases, 1 or 3 misdemeanor cases, all with the same alleged victim. He is now wanting to waive his jury trial right and have a bench trial on his felony cases, despite the fact that pretty much everybody has told him, look, this is not in your best interest, and you have a way better chance at winning, the most important one, at least, well, actually all of them, with a jury present. And so, he is insisting on that. That's his right. And it really sucks because he's making decisions that are not in his best interest, but are pretty understandable considering how long he's been sitting in jail waiting. And, we'll have a date set for him to do a jury trial, then it'll get bumped. Or, then the jail spikes and it'll get bumped. And so none of his trials have gone, and I can understand his frustration, but it really sucks to see somebody making such detrimental decisions based on the fact that the system is can't provide what they need to. And he hasn't been found guilty of anything. He's been sitting in jail for a long, long time.
Right. So he's detained.
Yeah, he's preventatively detained on at least one of the felonies. And so he's sitting in jail. And, we've been trying to get his misdemeanor case done because that's going to be kind of the pilot to see how well the alleged victim is going to testify in the future cases.
Yeah. I was wondering how much that dichotomy between whether you're out, right, and whether you're in custody is actually affecting the plea process as well. Loren, why don't you tell us what you're seeing?
Yeah, so I would say that out of custody clients are getting very good deals. They are trying to clear that calendar because it's growing and growing and growing, mainly because early on in the pandemic, they were releasing so many people, and the emergency bail schedule allowed for so many people to be released. And that maybe around September, October, judges just kind of stopped doing that. So now our numbers are back high of in custody people. So the out of custody clients are in a very good position to try to negotiate their case to a positive outcome, unless it's something really serious. As far as our in custody clients, I would say the pleas are okay. They're not as good as you would think they would be for some of the minor felonies we're seeing, and because of that, we're generally not having any pretrials before preliminary hearings. So we're just going straight forward to the evidentiary hearing, and then often our clients just want to set a no time waiver jury trial, which puts us in a position of getting probably a really bad offer right up until you get to a trial court. And I think the trial courts, those judges, they don't want to be doing trials either. So you definitely have judges really twisting arms and talking to everybody separately, trying to get some sort of deal to happen in order to prevent these jury trials from going out, which is one reason why it's mostly been the homicides and the really serious cases that are going. The other things are ended up getting resolved, usually to something better than they would get normally.
Yeah, that honestly, like, I'm a civil rights litigator. That sounds like civil court, where you have a judge telling you to bring your toothbrush because if you can't figure this out, they don't want to go to trial. Zach, what's happening in Oregon with pleas?
So we've got sort of a mixed bag. The misdemeanors out here, they sort of set like fire sale deals where they just did mass dockets of folks showing up and getting, pleas for a sentence of discharge or misdemeanors treated as violations. And so we had some attorneys that would, take 15 files out and close them all, in an afternoon. Some of the minor felony stuff, we're getting slightly better deals just to resolve them. The biggest issue that I still don't think that we've seen the head of is that most of our major felony cases have mandatory minimum prison sentences that a judge can't do anything about. And so we're still sort of at the mercy of the DA's office as to, what are they going to do? Judges are are itching to resolve things any way they can. And so if we've got some of the especially, bad cases where their enhancement facts a judge does have some discretion on, we can set those where a judge says, look, I will give you the, mandatory minimum and get this case out of here. But the cases where we're trying to get something better than the mandatory minimum, the DAs are still not sort of resolving it. And so now it's like our jail is almost full of these, major felony mandatory minimum prison cases. And so we're hoping that comes to a head soon where they just sort of have to bend. But in that sense, we haven't seen much headway there.
Maybe your legislature will take a knife to measure 11.
There are a couple bills out there right now. That's what we're hoping for.
Kelly, I saw you nodding. I was like, she wants to move to Oregon. They're giving those good deals on misdemeanors. Okay, so that actually takes me, I want to stick with this concept of asking the question, are there good things? Are there things that you hope that came out of this that'll continue? And I think back, Zach, to, I don't actually remember exactly who it was who was saying they can now access their incarcerated clients through a video portal from their home or wherever. That strikes me as a good thing. Are there other good things that you hope will carry forward that you've seen kind of improvised as a result of COVID?
I would say that the video proceedings, like the pretrial proceedings and the sort of disposition negotiation hearings, those being moved and those other small calendars being moved to video, I actually think does save significant time, because where we used to spend, it used to be the practice, at least in Alameda County, was the entire morning you're in court waiting with everyone else to try to get your two cases called from 9 o'clock to 12 o'clock. And sometimes you have to come back at 2. And you can't really do anything else while you're sitting in court. So I think that it's definitely worth considering whether some of these calendars can be moved to this forum, and that our clients don't necessarily need to be present for them if we have access to them on video or by phone. I think that would benefit us as practicing attorneys. Obviously, our clients like to come to court and know what's going on, but that's one thought I have of things that have saved an immense amount of time throughout the past pandemic.
Zach, anything you'd keep?
Yeah, I think similar to what Loren was saying, we've got, mass arraignment dockets or these case management dockets where, a dozen attorneys show up with 3 or 4 clients each. And the court, at least our court, has been very draconian in terms of contacting calendaring. And so everything used to require a motion for you to, appear telephonically, or your client, or to move dates or anything. And so the court has gotten a lot better about just being pragmatic. And if the DA and yourself are in agreement to move this court date or don't take it off the calendar, we can now just email calendaring and say, we don't need to do this, or email and say, I'm going to be appearing by phone, my client's appearing by phone. And I think that's a much better use of everyone's time. And now the fact that we finally get to call into our clients in jail has been huge, and something we've been trying to do for 6 or 7 years.
Kelly, any positive?
I agree with what Loren and Zach said, that the pretrial conferences are a lot better. And also the judge can't smell your client's alcohol in their breath. And so nobody gets arrested at pretrial hearings for being, kind of messed up in court. Additionally, I don't know if it could be done, but I love video probation violations because nobody can remand your client over video or over audio, or they could, but good luck.
Alicia, you got any that you've seen that you'd think are sort of clear positives?
Well, I think I think I'd echo a lot of what the other folks have said, especially about kind of these conferences, et cetera. I think a lot of people have seemed to find those to be efficient and a net benefit. I think stepping back, what I'd say is that as courts are developing these policies, it's critically important that they be consulting with, the defense bar, as well as other, kind of a diverse set of stakeholders, because I think people are going to come at this from different sets of experiences. And like I said, the surveys, et cetera, that we've seen suggest that judges aren't always going to be attuned to some of the challenges that remote proceedings or even in-person proceedings, some of the ways that things are being done now in various ways, judges aren't always going to see all of the ways that things are challenging or maybe implicating people's rights. And so something, that I think just needs to be part of the process going forward is kind of a broad consultation with stakeholders really baked into the policy-making process.
Right. And I want to say that the ABA actually has really good policy on that. Back in August, we passed a policy regarding online courts that calls for the creation of committees to either review existing procedures or come up with the appropriate procedures that involve kind of calling together all stakeholders to weigh in on those. I couldn't agree more. I think this, so many, I've done a lot of misdemeanor court observation, and so many courts have monthly calendar calls, which are really just check-ins about discovery, and they make the client show up every single time. The one thing I would add to that is, man, pretrial services and probation are both finding out that they can do check-ins by phone. And rather than requiring people to come back to courthouses and meet in person, whether it's weekly or biweekly or once a month, the more we can kind of eliminate the need for our clients to miss work or deal with childcare and come to a physical space when nothing particularly important is being decided. I think that would be really wonderful going forward. The last question I have for everybody concerns the backlogs, because one of the things you all have said is that while there are these cases going forward, they're a relatively small number compared to what would normally be happening. And Alicia, you gave that statistic of 9 versus 800, which is just overwhelming. What is the future hold as we start to do more of these? What are you all facing in each of your jurisdictions in the way of a backlog? And without going into details on what that planning might be, is there some planning going on for what will happen when the courts are able to increase capacity again? Kelly, I'll start with you because misdemeanor is kind of the land of numbers.
I think most judges have been moving their dockets. Some judges haven't been doing much of any trials, but there's not really much planning because we don't really find out until a week or two before what the Supreme Court is going to declare the rules to be. So I don't think there's a great deal of planning going into it. I think that the public defenders is pretty well set to deal with it because we can deal with anything they can do because there's only one of them and there's one of us. So it's not like they can set more than we can handle. So I think we can set whatever they can handle. I mean, we can handle whatever they can set. But nobody's planning, as far as I know, for anything.
Zach, what's going on in Oregon?
Like I said, I'm not entirely sure, and I don't know that the court is prepared yet. They did this sort of 3-week program, like I said, where they just resolved a ton of misdemeanors. And so I think that they will probably have to do that again at some point because the backlog is getting there. There's no misdemeanor trials going out and cases are getting old. So I think they'll probably have to do something like that. And we're hoping that the DAs sort of bend on these mandatory minimum prison sentences because otherwise it's really just major felonies for the foreseeable future. Even when we go back to, full capacity, we've got enough major felony trials to fill all the courtrooms for, indefinitely with trials. So there's no real plan in place, and we're hoping that, that someone comes up with something to deal with it.
Loren?
Yeah, it's kind of the same as what Zach's saying. And, Alameda County, which is, Oakland is the main area. The number of major felonies like life exposure felonies that are piling up are just in the probably dozens, if not hundreds of cases that are just kind of, our clients are perfectly happy to just wait because, 50 to life is, I can sit for another year while this is going on. So I don't know what the plan is going to be. We often are lobbying to try to get the deal makers on the other side to switch to people who are maybe more reasonable, but we don't have a whole lot of leverage to get the DA to put better people in those positions. Right now, it's just one person. If you've got a felony, or actually it's two people, so North County and South County, if you've got a felony, you're going to one of those two people to ask, beg, plead for a deal, and if they're not giving it to you, then it's not going to happen unless you get to a trial court with a judge who's got some pull. So I think going forward, the judges already in some of these pretrial video cases are already setting dates in April and being like, if the courts are open, your client's ordered to appear kind of thing. And that's just sort of rote. They've been saying that since October, and, in January, if the courts are open, your client's ordered to appear, so I imagine once the courts open, then it's just going to be a huge wash of people, hopefully vaccinated, who are coming into the court. But other than that, I don't know what the plan is going to be. It's kind of nauseating when I think of my caseload and what awaits, but we'll see what happens.
Well, and that combined with state budgets could create a real nightmare. I think Alicia and I are both kind of watching that very closely. And I have to say, I think that's exactly right. I personally, I live in a grand jury jurisdiction. I've actually served on grand jury. And I think the number of summonses that will be going out over the summer, if we actually get to the point where we have kind of widely available vaccine and they're back to calling people in, is going to be just incredible. Alicia, you have any predictions about the future you want to kind of send us home with?
No, I was really going to make the point about budget cuts, that I think the backdrop to all of this is, I'm really worried that in the dire fiscal environment that we're going to be entering into, that we're going to see, courts and other services targeted in ways that are going to exacerbate all of these backlogs, sort of the exact opposite of what you need to be doing right now.
Or on a positive note, maybe we'll finally shrink the system to its appropriate size.
Yes, that is what we should do.
All right, we're going to leave it there. I want to thank you all for joining us. I really appreciate our esteemed panelists from across the country making time to do this. These webinars are useful not just to the people who attend, but I know many professors who go in and edit them and use them for classes and all sorts of other things. So I really appreciate you taking the time today and talking with us about this important topic, and I will inevitably be following up with some of you about some of the things that you're seeing. I want to thank our audience for joining us. And the section for civil rights and social justice provides free webinars and resources for legal professionals and advocates nationwide. We very much hope that this helps you in your work. And if you can, please join the ABA. I know that's really hard in this time to ask people to join anything, but we're working hard to try and get this information out and help our profession kind of work its way through the pandemic. And CR and SJ and SCLADE in particular are really interested in assisting public interest lawyers, including public defenders. So thanks everybody, and please keep an eye on the website for future programs that might be of interest.